Everybody, my name is Faye Collinson and welcome to this afternoon's seminar, which, as you'll see, is on the decision from the Court of Protection in ACC and others. It was the decision of Her Honour Judge Hilda from February of this year. Just going to mute you all there. Many of you will have read the decision yourselves, but you'll know that it is a decision of significant importance to those who are involved with the property and affairs field and who also act as deputies. And it's also important for those who are instructed by deputies in third-party litigation to have an understanding about the implications of this judgment. And as is characteristic of Judge Hilda's decisions, it is very well crafted and it is legally coherent, but the implications of it for you guys on the ground dealing with peace, property and affairs, in my view, are quite significant. And I hope that today we have the opportunity to discuss the significance of some of those. Before I get into that, just a few matters of housekeeping. I apologise to those of you who have attended my seminars before and you've seen this slide a number of times, but I've muted you all, so if you wouldn't mind keeping your microphone on mute, please. You can use the function here to ask questions. For those of you who aren't familiar to Zoom, certainly I'm using it all the time in my practice at the moment. You can ask questions using the chat function. You can ask those either to the whole group or you can ask those to individuals. It's going to be quite difficult, I think, for me today to answer those as I go along because I'm essentially doing this seminar, certainly a large part of it on my own. So what I think is helpful is if you can leave your email address with your question, then what I very often do after a seminar is round up the questions, give sort of broad answers to those and send them out on a group email. And as always, if you've got any feedback about the seminar, at King's Head, we really appreciate you if you can provide that to us, of course, if it's good. But if you do wish to provide feedback, then there is the email address on the slide, seminars@kingschambers.com. And of course, if there are any seminars that you want us to deal with as a team or individually in the future, then do let us know the topics. At the moment, because of the set of circumstances we find ourselves in, we're really endeavouring to hold seminars as frequently as we can. So we do appreciate you suggesting topics that will help you in practice. So I'll get these slides to work, hopefully. So for those of you who don't know me, my name's Faye and I'm a barrister at King's. And many of you I do know, I work with you very often, and you'll know at King's that we are specialists. We don't dabble in any area. And so we mark our cards fairly on and pick our specialist areas. And my specialist areas are threefold. It's wills, trust and probate, particularly the contentious probate. It's like EastEnders but with law, so I love that. And also property as well. And those two aspects will lend themselves very well to my property affairs court of protection practice. I'm one of those barristers that I'm always happy to pick up a phone, discuss a case formally without having to send through formal instructions. So if you do want to get in touch with me afterwards, then there is my email, fcollinson@kingschambers.com. And there is the email address of my two clerks, Louise and Luke. So do feel free to get in touch with them. They'd be delighted to help you with any matters. And also there is my Twitter and the Twitter of the King's probate team. Not doing very well with these slides, am I? The format for today is twofold, really. I'm going to go through the case because I'm conscious that some of you will have read it and be very familiar with it, and others may not be so. And so I'm going to go through the case, what Hilda says about various decisions within the case, and also give my view about some of the implications of it. And then at the end of the seminar, I'm going to draw on the expertise of three individuals who I'm hoping have logged into today's seminar. Otherwise I may find myself having a panel discussion with myself. But those three ladies are Helen Forster, who is a deputy and solicitor at Legal Studio in Leeds, Lucy Taylor, who is a principal associate at Shoesmiths based in Birmingham, and then last but not least, we've got Sophie Robinson, who is a chartered legal executive and also acts as the deputy at Sintons in Newcastle. So we're going to be discussing a number of aspects of the decision and how it's affecting those three individuals involved in cases of property and affairs, how it's going to be impacting on them. Now, this case of ACC concerned three separate cases that were all heard together and conjoined because they all involved issues that required determination together and all interestingly involved effectively the same set of solicitors. But the issue that drew all these cases together was in what circumstances can a property and affairs deputy recover the costs of legal proceedings, which are both estimated, so future costs, and ones that have been incurred from P's estate. Now, by the time all three cases had been or came before Hilda, the legal costs had already been incurred by the deputies. So Hilda was approaching these applications for approval retrospectively. The legal costs that Hilda was concerned with fell into personal injury litigation and also appeals to the first tier tribunal where they concerned education, health and care plans. And finally, none of the deputyship orders gave those deputies authority to incur those costs and pay them from P's estate. So in broad terms, what the court was looking at was when does a deputy have the general authority to incur legal costs and when don't they have the general authority to do that? So she had a really detailed consideration of what falls into the general authority of a deputy. So just to give you a brief overview of the facts of each particular case, we first got ACC, and it was a large settlement of £3 million for a personal injury claim. Now, Irwin Mitchell Trust Corporation was appointed as the Property and Affairs Deputy for P in this case. And what had happened in 2018 was that the deputy sought advice from Irwin Mitchell, firm of solicitors that are well known, which are of course two separate legal entities. The deputy sought advice from Irwin Mitchell's public law team on the local authority's decision to end support that was provided under an education, health and care plan. Knowing that that appeal was potentially on the horizon, the deputy made an application to the Court of Protection prior to the costs being incurred. As those of you who are involved in this type of work know, the deadline for appeals of these to these tribunals are very short. I believe they're 2 months. So even though the application had been issued at the Court of Protection, it hadn't actually been considered by a judge before the deadline expired. So the deputy found themselves in a position where they were forced to issue the appeal in order that they complied with the deadline. And those proceedings concluded in May 2019 by way of a mediation. So by the time the case was considered by Her Honour Judge Hilda, the costs had already been incurred, the appeal had been concluded, and so it was a retrospective application for authorisation of costs. Now, the second one that we have is that of JDJ, and again, a large settlement that formed the estate of P. In this case, it was a solicitor from Irwin Mitchell's that was appointed as the Property and Affairs Deputy. Now, P's parents had identified a placement which was a specialist educational placement that they wanted P to attend. But the local authority took a different view and made a decision in the December 2018 that P's educational needs could be met within a mainstream college. So the parents wanted to effectively challenge that decision. knowing that there was a challenge on the horizon, the deputy made an application in January 2019 to pay the legal costs of P's parents in bringing the appeal from P's estate. Now, as with the previous case, the deadline for actually lodging the appeal was very tight. It was by the 10th of February 2019. So the application was made for approval a matter of 10 days before the deadline expired. What ultimately happened is, despite what seemed to be quite positive prospects as set out in advice by counsel, the appeal ultimately failed. And the application that was issued in the January 2009 again became an application for the retrospective approval of those costs that had been incurred by P's parents. So what the deputy was asking here is, can I have approval to pay the cost of a third party from P's estate? And the next one that we have is that of HPP. And this was where the Trust Corporation was here appointed as P's Property and Affairs Deputy. Now, the Deputy had been appointed in 2015. A personal injury claim was made, it seems from the judgment, in around the 2018. Certainly the litigation friend, who ultimately was a solicitor from Owen Mitchell, was appointed in the civil claim in the June 2018. But it wasn't until the September 2018 that the deputy made an application effectively authorising the solicitor to act as a litigation friend and be paid from P's estate for acting as a litigation friend, and also authority to instruct Owen Mitchells and provide the litigation friend with an indemnity for her costs from those proceedings. At the time that the hearing took place, the personal injury claim was ongoing, liability had been admitted, but quantum was outstanding. Subsequent to the attended hearing, it seems from the judgment that the claim actually settled. But again, it was a retrospective application for approval of costs. And so what the court was essentially faced with here was two different deputies who wished to pay legal costs from P's estate. And it's interesting, I think, worthwhile to pause and think, well, what do legal costs mean? Because they're not simply the litigation costs of the personal injury claim or the actual appeal that was made to the tribunal. Legal costs in this context mean a number of things. They include here obtaining advice on the proceedings. So the advice that one would ordinarily obtain, whether you have capacity or not, on your prospects of litigation before you actually start the litigation. It encompasses the costs incurred in the proceedings themselves. So that's going to be the litigation friend's costs, but also the costs that may be incurred in an adverse cost order. It also encompassed here paying a solicitor to act as a litigation friend in proceedings. And it also encompassed payment of a third party's legal costs from P's estate and tribunal proceedings. So it's important to understand going into this judgment that we're not just talking about litigation costs in the civil sense, but really all manner of legal costs that could affect P's estate. And so the issues here were, in my view, twofold, really, when you condense it down. It was, when can a deputy pay those costs, those legal costs, without having to seek approval from the Court of Protection? So really, when does payment of those legal costs fall within a deputy's general authority? And which costs don't fall in the general authority? Looking at it another way, in what circumstances and when does a deputy, before they incur those costs, have to go to the Court of Protection to extend their authority to include those? So that was the first key issue. The second issue that was a broader one that arose from the circumstances of this particular case was about conflict of interest. And because you'll see from the facts that I've described that the deputies were instructing effectively their own firms to act on their behalf in the litigation. Now, the question was, does that give rise to a conflict of interest? And if it does, what's the most appropriate way for a property and affairs deputy to deal with that? So, dealing with the first issue, which is about general authority. So what the court was really looking at here was, or is, when do these costs, these legal costs that we're thinking about, fall within the deputy's general authority? And you'll know that the usual form of the order gives the property and affairs deputy the authority to take possession, control of P's property and affairs, and then to exercise the same powers of management and investment as P would do as a beneficial capacitor's owner. And of course, any tasks or costs that fall to be incurred within the deputy's authority end there. They don't need to seek further approval. But what types of costs are those going to be? Well, the starting point is to look at, well, what kind of tasks fall within the general authority? And Hilda said that the general authority to manage property and affairs, which is granted by the standard deputy order, encompasses those common or ordinary tasks which are required to administer P's estate efficiently. Now, she recognised that using terms such as ordinary, common, quite vague, quite broad, but she does give some examples within her judgment about what those may be, which I'll come onto in a moment. But what she said is that where in carrying out those ordinary tasks, you have to effectively take advice, and that is an ancillary part of giving effect to that authority, then those legal costs will fall within your general authority. And so what we have to start with is, well, what are the general and ordinary tasks that fall within your authority? That's going to be fairly simple. It's going to be things like purchasing property, executing deeds, completing financial assessment forms, if that's going to be relevant, payment of bills, and then of course if P has a business, then it's going to be slightly more complicated than that. So any ordinary task will of course be determined by the estate of P. Now, there may be times when you are having to carry out an ordinary task for P's estate where you think, well, actually, I need the benefit of advice in order to make this decision. And that's where you have to think about the ordinary legal tasks. So those will be things such as tax returns, conveyancing, because of course, in order to carry out that function of purchasing that property for P, there's going to need to be a conveyancer who does that. That is an ancillary part of carrying out that task. If, for example, P is going to become a tenant and you need to consider the lease as part of that, and you may be unsure about the implications of certain clauses of that lease, then you may well think, well, actually, I need the benefit of some advice from somebody who has expertise in that. Again, that is going to be ancillary to carrying out your function of executing that lease on behalf of P. Another example that is mentioned in the judgment is about employment contracts. Now, it's very often the case that a deputy will employ directly carers on behalf of P. And you may find yourself in a position where the carer has committed acts of gross misconduct, and so you need to think about whether you can dismiss them. Now, you may not have the particular expertise to know how to go about doing that. And so you may need to seek advice from an employment lawyer to aid you in making that decision. Again, that is going to be advice that is ancillary to making that decision. And I think that the key really is this, is you've got to think about, well, what is the subject of the subject matter of the advice? Is what I'm asking for advice on an act that falls typically within my general authority? And do I need that advice to facilitate my decision making, which I know falls within my general authority? And as long as that advice is reasonably required, and once you've got that advice, you can then act on it, then that is going to be a legal cost that falls within your general authority to incur. But of course, there's going to be times, as many of you know, that matters can become contentious. And so there will be occasions where there is a matter that involves P's affairs, and there is the possibility that it will become a litigated dispute. Well, what happens with the costs of that? Well, ultimately, what Hilda said here was that the starting point is this: your general authority does not include authority to conduct litigation. Those of you who have acted as deputies for some time know that if you are actually going to proceed with litigation on behalf of P, you must seek the Court of Protection's approval to do that. And it's very similar to, for those of you who deal with non-contentious estates and contentious estates, the application of making a beddoes application to the Chancery Division. And what will very often happen there is you submit counsel's advice, you submit the evidence, and the judge will give a determination on the side or give a view about the likely prospects of success in that case. And the judge may limit the executor's ability to continue with that claim to a certain stage of the litigation. And it acts very similarly with the Court of Protection. The Court of Protection can allow a deputy to continue with litigation for the whole or the entirety of the litigation, or it can limit it up to certain stages. So that's the starting point. But of course, for those of you involved in litigation, we don't say, right, we've got a claim, let's go ahead with it. There's this pre-action stage. And of course, if you don't embark upon a pre-action stage, parties who don't do that can be sanctioned in costs at a later date. And Hilda, in her judgment, quite properly recognises there's that process before litigation starts, where there needs to be some consideration of the merits of it. And so the judge held in this case, and as a principle, that a property and affairs deputy is entitled to take certain steps in contemplation of litigation, and that is going to include the letter of claim. It's going to include receipt of the letter of response. At that point, then your authority to continue with that litigation ends. But there's a second condition to that, is the subject matter of the potential litigation must involve property and affairs. If it doesn't, then it's not an area that the deputy can get involved with. And so there is the scope for you to incur costs that are pre-action. That's going to include taking advice on the litigation, including counsel's advice on the prospects or merits of the litigation. It's going to include initial consideration of any documents that are in your possession and available to you. It's going to include drafting the letter of claim. What I don't think it's going to include is mediations, because of course they very often take place prior to a claim being issued. I think if you get to that stage, then you do need to seek the court's approval. But Hilda's quite clear that you can incur costs within your general authority up to receipt of the letter of response. If you go further than that, without authority of the court, then you are at risk of being personally liable for those costs if they're not ultimately retrospectively approved. The problem is, though, litigation doesn't always fall quite neatly into property affairs matters, because the judgment recognises that there are discrete circumstances in which there will be litigation that concerns P's welfare, but it also concerns P's property and affairs. And so the judge addressed expressly how a property and affairs deputy can deal with that. And she dealt with two instances, and the first was CHC appeals. What the judge said here is that, of course, your general authority involves you ensuring that P receives all the funds to which he or she is entitled to. And so following from that, the property and affairs deputy is entitled to take advice on the process of the application for CHC funding. And so if you're forced to, or if you need to take advice on that application process, then the court said you can do that, and it's within your authority to pay those costs from P's estate, subject to the issue that we'll deal with later. But as soon as the appeal gets going, then that is going to be outside the scope of your general authority. And so what Hilda said there is that once you have got past the point of seeking advice on the application, but it's turning into an appeal, that is when it is outside your scope and you need to seek approval for that. The second instance was education, health and social care plans. And as you'll see at the outset, when I set out some of the facts of two of the particular cases, they concerned appeals to the tribunals that adjudicate on these cases. Now, what Hilda said here is that ultimately this type of decision does not involve consideration of health and welfare, and the outcome isn't a financial one. And so anything to do with education, health and social care plans falls outside the scope of your general authority. So you are not entitled, without express approval, to incur costs in these types of claims and recover those from P's estate. What you must do, and Judge Hilda was quite clear about this, is if there is steps that a deputy wishes to take, including advice and including challenging the decision, then you must seek approval from the Court of Protection. But these types of cases, of course, involve an issue of timing, because the limitation period, if I can call it that, for making these types of applications is pretty tight. And so we all know that it takes a number of months for these applications to the Court of Protection to be considered. And as the deputies in the cases that were the subject matter of this decision found themselves in, particularly ACC, the deputy had made the application in advance of taking advice, but the court didn't consider it before the deadline expired. So it places a deputy in a fairly invidious position, I think. But what the court said here is, recognising the difficulty that poses to a deputy, was to draw the court's attention to the very fact that the application needed to be considered expeditiously and under the urgent business. Whether, practically speaking, that will actually happen, I very much doubt it, in all seriousness. But that is certainly what Hilda envisages occurring. And of course, if you then find yourself in a position where you've made the application, but it hasn't been considered by the court, and you need to actually lodge the appeal, then Hilda is quite clear that the deputy in those circumstances proceeds at personal risk. Because whenever a deputy who is a fiduciary acts outside their authority, they are acting ultra vires, and it is a breach of fiduciary duty, unless it's consented to. But of course, a breach can't be consented to by P. So until that breach or acting outside the authority is retrospectively ratified, then a deputy is at personal risk of paying those costs. So it's pretty scary stuff, I think, if you're acting as a property and affairs deputy. And I don't think that the judgment gives the assurances that perhaps some of us were hoping for. Another aspect that the judge dealt with was when third parties' legal costs can be paid for from P's estate. And that's when she dealt with the case of JDJ, because ultimately P's parents in that case instructed Irwin Mitchells to proceed with the appeal. What the judge said quite clearly is that there is no general authority for a deputy to pay a third party's costs from P's legal costs from P's estate, even if those third-party costs are paying for legal advice that ultimately benefits P. In those circumstances, the deputy must seek the Court of Protection's approval in order to sanction those costs being paid from P's estate. And another matter that was considered by the learned judge was, well, we've talked about third-party litigation, but what about actual litigation in the Court of Protection? And as you all know, there are two sides to the Court of Protection. Well, the court recognised that it would be illogical to expect a deputy or require a deputy to seek authority to bring proceedings in the property affairs side of the jurisdiction. So if you do need to make any applications, then you can just press ahead with that and save in exceptional circumstances, be satisfied that the costs of those will come from your general authority. But where we're dealing with health and welfare matters, the judge was very keen to draw a distinction there. And I think make quite clear that a property affairs deputy doesn't actually have any place getting involved in welfare disputes. And there's always been a bit of a discussion about that. How far should a deputy go in being involved within health and welfare contentious proceedings? And I think if there were any doubt about that, Hilda, to some extent, clarifies that by saying, if it's health and welfare and you're a deputy who is property affairs deputy, then you keep out of that. But what she did say is that there are very discrete circumstances where it will fall within your authority to incur costs in welfare matters, and they are discrete. And she said that effectively, if there is a health and welfare matter that concerns P, and it needs to be brought before the court, and one of the statutory bodies is not doing that, then a deputy is obliged to bring that matter before the court. It's quite similar to where you have executors who aren't quite sure what to do about an estate, and they will bring it before the court to seek directions. In my view, it's quite similar to that process. So you might have an example where there is, in your view, an unlawful deprivation of liberty in P's home, or you might have a concern that a husband and wife are living at home and there are welfare needs that are simply not being met by the local authority, and they aren't, or there is a dispute about their welfare needs and nobody's doing anything to resolve the matter. Then your authority enables you to make an application to the COP under the welfare side and bring it to the court's attention. But once you've done that, that is when you remove yourself from those proceedings, and you leave it then to the statutory bodies to deal with that dispute before the Court of Protection, and no doubt the family members. Now, what I always say to deputies here is, before you do that, make it abundantly clear to the statutory body that you think has the obligation to be sorting this issue out, that if they don't do what they're supposed to, then you may seek a cost order against them if you're forced to bring it to the attention of a judge in the Court of Protection. So it's worthwhile sending a pretty robust letter, and then if that fails and you feel that it's your responsibility to bring that before the COP, then you should do so. For my part, what is abundantly clear from this judgment, and I think is the overarching message, is that when you do need to seek approval for incurring certain costs, you must do that in advance of incurring those costs. And so if you don't do that, as I've explained before, you are acting outside your authority, and prima facie, you are in breach of your fiduciary duty, and you will be personally liable for those costs. The problem is, you may find yourself in a position where you simply cannot do that because of time pressures, limitation periods. And so Judge Hilda addresses how you should approach that. The starting point is that unless there is good reason not to, you should be seeking approval in advance. If you are faced with a situation, for an example, an injunction or one of the educational appeals that we've referred to in this seminar already, then the judge encourages you to make the application prospectively and then seek the court's approval and ask them to deal with it urgently. As I said before, I think in practice that is, well, theoretically that's a good suggestion. Whether in practice it's going to work, I'm not convinced, because the backlog, as you know, of cases being considered, and I've certainly got a case ongoing at the moment, which is by no means urgent, but we do need a decision soon. It's been months since we've had any contact from the court, and we're still left without any authority to proceed with recovering some money for P. Now, he's not a life or death situation, but he certainly needs that money. And so to him, it's certainly urgent. But what the judge said is that if you proceed and you don't get your approval, then you do so at your own risk. And I think that that's where the judgment's a little bit disappointing, really, because the applicants encourage the judge to say or give some guidance or assurance on, if a deputy does do that, they're clearly trying to act in P's best interests. They are forced into the position where they've got to act urgently and the court can't deal with it. Why should they be taking on all the risk of making that application, particularly when they're there as a professional? But the court declined to give any assurance that when the court considers it retrospectively, that it would grant that approval. And I think that that's where it becomes a little bit disappointing. But what she did say is that proceed at your own risk, but make your application for retrospective approval as soon as you can. The longer the delay, the less likely I think it will be, or the harder it will be to convince the court that it should have retrospective approval. Are your actions reasonable? And also an outcome or actions that are clearly designed to protect P's interests. And of course, when you did those actions or carried them out, you did those believing them to be in P's best interests, then that places you as best as I think you can to convince a court to retrospectively approve that action that you've taken. And I think what you'll have to do in your evidence is present quite in a detailed manner why you weren't able to make the application in advance of those costs being incurred. So the second issue is conflict of interest, and I'm going to just go over this relatively briefly, because I know that in the discussion we're going to, Sophie's going to deal with this. But the question was this: if a deputy instructs their own firm, is there a conflict of interest? And I think the quite clear answer to that is yes. And so the court set out a particular approach that a deputy, faced with having to seek some legal advice on, for example, ordinary tasks, the process that they have to go through in order to do that. And that process, I think, is going to burden deputies unnecessarily so. But that is the quite clear message from the judgment, that these are the steps that have to be taken. But as I say, Sophie's going to discuss those in greater detail. Now, the outcomes of the cases were these. In ACC, the judge appeared to have very little problem in retrospectively approving those costs that had been incurred by the deputy in the appeal. She said that P had clearly derived a benefit from the steps that had been taken by the deputy, even though those steps were taken in breach. And as I say, the application was ultimately settled by way of mediation, and the costs that incurred were relatively modest. But it sort of begs the question for me is, if it's so plain that it should be retrospectively approved, then why not just make that as part of a deputy's general authority? The second one, JDJ, ultimately the application was approved retrospectively, but those involved in the case didn't get away without, I think, some level of criticism, because the appeal to the tribunal was unsuccessful, notwithstanding there having been quite positive merits, and the costs of that appeal were quite significant. And the judge, despite having those concerns about those aspects of the case, ultimately ratified those costs. And she did so, it seems, for these reasons, really. She said that the deputy had proceeded on the advice of counsel, and that was material to her decision, because very often, certainly in probate cases, trustees, if they obtain advice, can rely on that as showing that they were reasonable in taking certain decisions. So it's perhaps a similar thinking behind that. I think one of the most important factors for the judge was this, is that because P's parents had incurred the costs, if the deputy couldn't pay those from P's estate, then P's parents were going to be left out of pocket and by a large sum by all accounts. And there was the valid argument, I think, that it's not in P's best interest for his parents to be quite significantly out of pocket. And that's something that the judge agreed with. But what she did say is that the court will not likely authorise actions retrospectively when there is no good reason why authorisation was not sought prospectively. And I think that's really important to remember from this case, because if you have cases where you've just not got around to seeking approval because you're dealing with the substantive litigation, and then you come back to the COP halfway through that litigation, after this judgment and this clarification, it's going to be more difficult, I think, to persuade a court to retrospectively approve those costs. So really, the starting point has to be COP approval, and then you carry on with the substantive litigation, unless there are, of course, limitation problems. And this is where I think she's giving a real warning to everybody here, because she's saying nothing in this decision should encourage property and affairs deputies to consider that there will be, on other occasions, a similarly positive determination of applications effectively to authorise litigation after the event. Appropriate authorisation should be secured in advance. To me, she's giving a really clear warning there. She's saying, unless you can't, and unless there's good reason, then you must seek that approval in advance. And if you don't, then as a deputy, you will, I fear, find yourself being unable to seek retrospective approval. And as I say, then at being personally liable for those costs. And the final one was HPP. Now, there are a couple of strands to the application. The first one was whether the litigation friend, who was the solicitor at Irwin's, should be paid fees from P's estate to simply act as the litigation friend. And at this point, understandably, the OS had reservations about this. And the official solicitor essentially offered to act as the litigation friend for free in this case, and therefore said it cannot be in P's best interests that there should be a paid litigation friend when there is an unpaid litigation friend available. That then prompted, I think, Irwin Mitchells to offer that the litigation friend then act for free. So it meant that that particular issue fell away. But the court made it quite clear that the circumstances in which there should be a paid litigation friend when there is an unpaid litigation friend available, those circumstances when that would be preferable are going to be remote. Now, one of the then the other issue was whether the cost of the actual PI claim should be authorised from P's estate. And I think there was a sort of veiled criticism here, because there was concern about the CFA uplift that was incurred as a result of the deputy instructing Irwin Mitchells to deal with it. And what the court had effectively said is that really while she was approving the application retrospectively, she did it with some reluctance. And I think she felt there was some reluctance because she felt there was an inherent conflict of interest in the firm acting as litigation friend, then acting as a solicitor's on the actual substantive litigation, because when you have the CFA uplift, there wasn't the opportunity for P to go and shop around on the market for solicitors that may have done it for a more competitive price. And I think what Hilda is really trying to press upon us all in this judgment is that don't think you can bulldoze into litigation, get stuck into it, and then say to the court, well, we can't now step out because we're too far into it, and bringing in a new solicitor that may do it cheaper is going to cause duplication and delay to P. I think what she was encouraging solicitors to do is not to do that, and that's why she's so insistent that any approval application should be made right at the outset. But ultimately, I think through gritted teeth, the judge did approve the instruction of the solicitors, and she allowed the litigation friend to be indemnified for her own costs, of course, those costs of instructing Owens, and any adverse cost order that may have been incurred. And so it's at this point that I'm going to ask Helen and Lucy and Sophie to join me, if they can unmute themselves.
There we go. Hello, can you hear me okay?
I can, yep.
Hi, it's Sophie.
Hi, Sophie.
And I'm here as well, it's Lucy.
Great, great. Okay. Well, thank you very much for joining me, the three of you. And what I want to do is just, I think if we start with Helen, who, as I say, is a deputy at the legal studio in Leeds. Helen, I talked about my concerns about the COP being able to deal with the urgent applications. From your experience and how things are lying at the moment, do you think the COP can accommodate the urgent applications that Judge Hilda has suggested?
Oh, in short, and I think you answered this earlier, I don't believe it can. The length of time it takes for applications in general, as I'm sure everybody on here knows, is substantial. Equally, what I find is that on many of ours, we submit an urgent application via the usual path, the COP9, and it's essentially ignored and not dealt with for several months. So we have quite a disparity in terms of how long these things take, and perhaps what we regard as practitioners as urgent and what the court regards as urgent. Mm-hmm. So I think there needs to be some clarity here, because what this is going to do is, of course, create a flurry of new applications that are going to have to be made to ratify decisions that have been made historically on costs, which of course is just going to tip the court into even further delays. Whilst I appreciate what Judge Hilda is saying, that you can submit an urgent application, I think they need to really address the situation in terms of their turnaround times, because if you read the practice directions, they say quite clearly that it should be looked at within 5 working days. And I don't know if anybody in this room today has actually had one back within 5 working days.
I was going to say, does that actually happen in practice?
Unless it's extremely life-threatening, then I haven't had one through within 5 working days. My last one took 3 months. So, you know, what I regard as urgent, what they regard as urgent is quite problematic. I also think there needs to be a bit of clarity on what she defines as normal in terms of what we do on our day-to-day matters, because each deputyship can be completely different. So, for example, a lot of my clients have clinical negligence settlements where we have to employ carers or support workers. But similarly, there are people that deal with deputyships where none of that is required. It's kind of like little old lady in a care home. So what is normal on one deputyship isn't going to be classed as normal on another. So I think there needs to be some real clarity on what Judge Hilda is saying and defining as what comes within our normal day-to-day running, and then therefore what is within our scope of authority. The other thing that I note from this is that obviously she's basically saying a bit like our OPG forms where we have to predict our costs. We're going to have to predict what applications we're going to be doing throughout the year and making a prospective application. In some cases that might be feasible, but in a lot of other cases they're not. So for example, there might be a case where I'm appointed as a deputy and suddenly there's been misappropriation of assets before I've been appointed. We're going to have to look to get freezing orders, and I can't prospectively make an application for that. And equally, I can't wait for the court's timescales in order to start that off because the assets could be anticipated.
Sorry to cut across you. I think that's a good point, because certainly I deal with a lot of misappropriation by usually attorneys, lay attorneys, I hasten to add. And you find yourself in a position where you need to make a very urgent decision about whether you go for an injunction or not, because you want to take whatever step you can to preserve P's assets. And in the same vein, you've got to consider what the test is in the civil jurisdiction. And part of that is delay. Because if you delay in making a freezing injunction, then that can, in certain circumstances, be a bar to obtaining that relief. And so you've got this inherent conflict between trying to do the best you can as a deputy to preserve P's estate, but then you've got the potential of personal liability, which I don't think is what anybody has signed up for. And I also don't think that is what the judge intends by this judgment. And I just wonder if it's a case of a theoretical legal judgment that doesn't necessarily sit well or cohesively with day-to-day what you have to do. And I wonder if that will put off people maybe acting as deputies.
Yes, I believe it will do. I mean, I've seen a lot of people drop off anyway because of the way the cost structure is dealt with. And I know that EOPG is looking at this in particular for clients whose assets are less than £12,000. They're going to review how the structure is dealt with in terms of how we get our costs. But a lot of people have already been put off by that. Our scope of authority appears to be significantly reducing in terms of what we can do day to day. And of course, as deputies, we're signing up to say we're going to act in P's best interests. So it's creating a bit of a conflict, I think, for deputies themselves. If we have to consider making an application for all of these things that are considered by Judge Hilda to be outside of the scope of our authority, things do crop up. Simple things like having to try and call in a bond. These are things that I normally wouldn't have an issue with, but now, because of Judge Hilda's kind of case and the way she's discussed things, I'm then thinking, well, can I actually do that? Because if this involves litigation, do I have to apply for authority first? I believe that
that's where you need to draw your line between your third-party litigation.
Yeah. That's exactly it. And whilst I do have some sympathy, and I know Sophie's going to discuss this in more detail, I do have some sympathy with her thinking that we should obtain quotes before just using other members of staff. We've got to show that what we're doing is in P's best interest. So usually we would have to do some form of assessment in terms of why this is in P's best interest. So follow your normal assessed processes in terms of why we believe this will be in his best interest. Usually things such as, we can obtain the papers much easier, so a colleague has access to the information straight away. There's no delays of having to go to different firms. It's all there and in hand. Again, getting 3 quotes is going to deter, I think, people significantly from doing this work, because the whole point of this.
I'm probably going to bring Sophie in. Sorry, Helen. So I'm probably going to bring Sophie in at this point, because I know that Sophie was going to help us with when you have identified a conflict of interest, what steps you need to do in order to instruct your firm. And I suppose what you need to be mindful of is, as we know, when you're a deputy, you're obliged to use lower grade fee earners to kind of delegate the running of P's estate to. But what we're talking about with conflict of interest is when you're using someone from your own firm, so maybe from the conveyancing department or the probate department, to advise on an issue that is ancillary to your general authority. And the court set out some steps that, Sophie, if you could help us with, what they involve.
Yes, so if you are now looking to have this authority as part of your court order, there's essentially two routes to do it, or within your authority. The first is if you are applying to become a professional deputy in relation to property and financial affairs, and you do have that understanding of case circumstances, and you can foresee that you are going to need some legal advice in the future, then you can incorporate within your COP1 authority to be able to instruct your firm to be able to do that. If you are in a situation where you already have a court order and you don't have authority within that to instruct your firm, which I anticipate most of us are in that position because we've never really looked to get that authority within our court orders before, then in those circumstances, what you can do is you can look to get quotes from other firms that are out there. The difficulty is from the guidance that even if you do have that authority and you are getting quotes from other firms, including your own, then even if you go ahead and instruct your firm, but those costs are going to exceed £2,000 plus VAT, you still need to go to the court to get those costs approved. So you could have taken all of the relevant steps that you need to, and you've still got to go to the court in any event. Obviously, if you are in a situation where you've gone out there and got 3 quotes from different firms, you've then made a best interest decision and decided to instruct your firm, and then you find out the court is the fees in excess of £2,000, you've then got a situation where you've got to make an application to the court, and you've got all of the additional charges and time frames that are added to that. It's a real deterrent from ever going ahead and instructing your own firm. So it's going to be difficult, I think, in terms of getting that authority.
Yeah, I think I'm just going to pick up on one of the questions I've just been sent. Someone's asked, I'd be interested to know whether simply having the cost of your firm assessed as part of the general management file by the SCCO is okay. And this is one of the points that when we discussed with Lucy about the EHCP plans is a real concern of mine about previous cases that have all been done and dusted. You've had it assessed, you've been paid, so it doesn't form part of your caseload anymore. But the FCCO, that goes to assessment, so all the determinations that go with assessing costs of deputies, but it doesn't go to the principle of whether they could be incurred in the first place. It's like with civil litigation. Whenever you think about costs, the first point of call is, what's the principle of cost? Who's going to pay? Then you go on to the second stage, which is the assessment, reasonable and proportionality of those costs. And I think saying or relying on, well, the SCCO said my costs are fine, therefore it's okay, that's starting with the assessment before the principle. And that is, I think, something that is worrying, because of what about previous cases where, as a result of this judgment, those cases were dealt with outside of the deputy's authority, but the SCCO said the costs are okay, but you still never had the authority in the first place to incur them. What does a deputy do about that? That, I fear, is going to open a big can of worms, and one I don't expect Her Honour Judge Hilda anticipated doing. And I suppose that then brings me on to Lucy at Shoesmiths. And Lucy and I have had quite a number of discussions about this judgment. But Lucy, from your perspective, what's your main concern about how this judgment's going to affect your particular caseload at the moment?
Yeah, so I can see that Gemma has commented in the chat about what people are doing and whether or not they're sort of taking steps now or awaiting guidance from the OPG. I mean, the first thing that we did post the judgment coming out, as well as talk to our peers, was contact the OPG and get guidance from those guys, because ultimately that's what they're meant to be there for. And what we were specifically asking was, okay, we've got three sorts of criteria here. We've got cases where we've instructed predominantly our in-house education team, and those matters have concluded. We've reported on them in our OPG report. Do we need to go now and get retrospective approval? And we broke that down a little bit more for them, and we said we are making the assumption that if the matter concluded before the last reporting year, that we're not going back that far in time. I think we got to draw the line somewhere. But there was still the question mark of what about if we're going to have to report on those costs in the current year deputy report? Do you want us to apply for retrospective approval in those cases where the matter has concluded? And then what's the position with regards to matters where we're currently instructing our education team and the matter is ongoing, but it's sort of midway through? Are we going out getting quotes from other firms to potentially take over the matter partway through when the deputy's already made a best interest decision? It's difficult to see how it can be in P's best interest to move an education matter which is partway through, where you've got all of the reasons why you instructed your in-house team in the first instance. They remain, they haven't gone anywhere. It was clearly in P's best interest to do it at the time. So the OPG did come back to us. I can see that a couple of people have said they're in the process of working on some guidance, and that was the response we got, that they are working to produce guidance on what their expectations are of deputies and what they will do post ACC. From our point of view, we are taking the view that anything that's ongoing, we're making retrospective applications for, and in the meantime we're waiting for matters where the work has concluded, and we're going to report on the costs in the report. We know that a couple of those will fall due, so we're just prioritising, quite frankly, and doing it on that basis and seeing where we get to. That's sort of where we are as a team, but it's far from clear. The other thing, in terms of the timing of it, I think it is really key. You've got a 2-month period for EHCP appeals, and it's all very well saying make an application on an expedited basis, but until the issue arises, you don't know it's there. Once it arises, what do? You down tools, you don't instruct your education team, and ultimately that can't be in anyone's best interest to leave it until potentially getting authority. So the other option is, of course, and the safest route is to send it off to another firm. That's the only way that you can remove the risk on costs on the deputy. Of course, that entails a whole other risk if you're not sure who you're working with. No doubt the firms who have very good reputations will be run off their feet, and so you've got to make that judgment call on, do you instruct your team, do you bear the fact that actually you might end up with an adverse cost burden, but at least you know that the client's going to get the work done and they're going to get it done properly.
Yeah. It raises a whole host of issues, and I think you're talking about your ongoing cases. I think you've got that need, if you take the judgment as strictly, strict form, that you need to take seek approval, because any step on that kind of issue is outside your authority. So I think it follows that you have to seek approval. And then you've got that conflict of, well, we're halfway through, but really through no fault of our own. It's not going to be in P's best interest to move firms midway. And I think that's where the balance is going to be, isn't it? And it may well be that you get your sort of in principle costings, but then the magnetic factor in the balancing act is going to be, well, actually, to move this to a new firm, delay, duplication, and ultimately that's prejudicial for P. So I think that is how the ongoing claims will be approached. But obviously for any new ones moving forward, then your approach is going to have to be slightly different. And I think this is where I'm slightly worried about the ones that have already been dealt with, because knowing, I do lots of breach of fiduciary duty and trust claims all the time with my executor work. And once you have a breach of duty, you're in breach of duty unless there is a defence, which in an ordinary world would be consent, acquiescence, something like that. But of course here in the court protection, you can't have that because you have somebody who lacks capacity. So the only way to remove that breach is to have it retrospectively sanctioned by the Court of Protection. Now, for historic cases, that hasn't been applied. So it seems to me as though those cases are still in breach without wishing to trouble anybody or worry anybody about it. But I think that has to be the conclusion of it. And it makes me wonder, well, say you have one of these cases that you did a couple of years ago, and it's cost however many thousands to do that case. It's all been okayed by the OPG and the SCCO for your costs, all paid, fine. But then what happens if P regains capacity and they say, well, hang on a second, why on earth were you using my money to do this? And that's not been costs that have been approved and retrospectively ratified. And I wonder what the answer to that will be.
I think we have to bear in mind that a deputy has never been able to litigate without specific authority from the court. And I think, you know, nothing's changed there. And we have to, you know, all be mindful of that, that there is another issue when it comes to costs. And I can see that some comments have been made in the chat of similar situations to this. And I just want to pick up on the OS point. There was a suggestion in re-ACC as that the OS would act free of charge. I would be interested to know if anybody else has ever had experience with the OS where they've agreed to act free of charge, because that's not been my experience of the official solicitor. In fact, they've always wanted certainty of how they're going to be paid. So don't think that's helped the situation. But we've always, as deputies, had to get authority to litigate. I think we can't lose sight of that point.
Yeah. So I was just having
issues in the chat actually. So Julie mentioned about the property purchases, and I know I've had problems with this as well, because purchasing property down south, they tend to get offers on and get snapped up very quickly. So she's raised the point of, should we how can we secure properties in that scenario? I would kind of propose that I would hope this would come under our general authority, in the sense of our COP 1's already set out, do you intend to purchase property? So it's already set out that it's accepted, this is something we're going to look at. So I would hope that the new guidance is going to address the issues. And of course, as you rightly point out, properties vary dependent on where you are in the country. So I'm in Harrogate, I know other people are down in London. You know, there's a clear disparity in terms of the charges. So what I would hope that would come in with the guidance would be some kind of system where we can acknowledge that, so you're not going to have these delays moving forward. But at the moment, you're exactly right to raise it, in that if we've got a £2,000 figure, you may need to get authority to purchase property and incur those third-party costs first. And clearly that cannot be in P's best interest at all. It is a clear conflict against what the Court of Protection says. The other point that I would mention is the costs for all of these applications. How are they intending these to be funded? Because if P is going to have to fund these extra applications, then again, that surely goes against the Court of Protection saying that costs should be reasonable and proportionate, because having to go back over to try and obtain these is surely going to incur massive costs on behalf of P, that under current situation prior to ACC, we didn't have to worry about. So I'm struggling to see how this case kind of drives forward what the court wants us to do as deputies. It just seems to clearly conflict with other things that have been set out in the professional standards and the Court of Protection rules and guidance.
One solicitor asked me about CICA claims, because they're not dealt with in the judgment because they just didn't form part of the substantive applications. And they work, I suppose, similar to, because obviously you appeal to a tribunal if ultimately it's a long time since I've done a CICA appeal myself, but you do an application, and then ultimately if that's rejected for whatever reason, you can apply to the various tribunals. And I was asked whether you need approval from the COP to do that, and my view is yes, you do need that. There is a case, I think, Senior Judge Lutt of Newcastle and PV or something like that from memory, where I think he made it fairly clear in that, certainly my reading of that, is that you do have to get approval to move forward with the application. And I think that's always been the case. And now what it will mean is, because what typically happens if you've got a firm that has your, you know, your deputy department, then you've got your PI department, who in my experience usually deal with the CICA aspect of it. So you're then instructing that department to assist you in that application, your capacity as a deputy. That's where the conflict arises. And so if you're looking to instruct your own firm to assist the deputy with that application, then my view is that you also need to seek the 3 quotes there as well. And that's going to be particularly important, because I think they're very often funded by DBAs, aren't they? So they take a proportion of the ultimate award. So I think there's going to be a real requirement to look at where P can get the best value for money for that, because I don't think it will be looked on particularly well if you've just looked at your own firm and they're doing a fairly high percentage, when Joe Bloggs down the road could have done it for a much more competitive rate. I just want to draw everybody's attention to Holly Chandler's been very vocal, so thank you very much, Holly, because she's provided some really useful feedback. And just the piece that she started off with, just to say that there is a cross-organisation group working on the issues that arise from the ACC decision. So it looks like the wheels are very much in motion to try and clarify matters for everybody. How soon that will come, I don't know, but obviously the sooner the better. And I think until the time as such when things are clarified to a degree of certainty, then you should proceed with an abundance of caution, quite frankly. But she said there very helpfully that if you do want to contribute to that discussion, then to email her at holly.chandler@morelaw.com. So if any of you do have any things you want to say that can be put forward to whoever is considering that, then I think that would be really, really useful. I'm just seeing if there's any other questions. So it seems like it's obviously a hot topic. It's produced a really interesting debate, and it's something that to me is quite clear that it's of real concern to everybody, because you are ultimately doing that job because you have a particular love for helping vulnerable people and doing the best for them. And I think this potentially hinders your ability to do that, because you are having to think more about your own personal risk as a professional. And I think that conflicts with your ability sometimes to make those decisions as quickly and efficiently as some as you were perhaps doing before. But hopefully with time, there will be some clarification. I certainly know that Judge Hilda is going to be speaking at the Professional Deputies Forum, to which as barristers aren't allowed, but no doubt I will get some feedback from you all about how that goes, and I hope that she provides some clarity on the reasons behind her particular decision. But unless, have you guys got anything else to add, Helen, Lucy or Sophie?
I think we've covered the main points, haven't we? I mean, there's a lot to worry about from this case. I think that perhaps Judge Hilda hasn't perhaps thought it through in other scenarios than she was considering at the time of the case. And I think it is just going to have a huge impact on how we deal with day-to-day matters unless the guidance really does clarify the situation for us. I think that it's opened up a can of worms. It's going to end up, there's going to be a throng of new claims to the court, which is going to cause an even further backlog. They're already saying the usual 6 months for an application is now between 9 and 12 months. So to extend it even farther is just, it's quite scary. And thinking that we're going to have to, try and get urgent applications through at the court, it just doesn't bear thinking about what's going to actually happen in the long term if we are forced in every single scenario to consider making an application.
Yeah, sorry to cut across you, Helen. There's just one point being raised about if there's a shortfall in the assessment of costs. When you are instructing so as a deputy, it seems slightly artificial that you're instructing your own firm, but you're technically the client signing the letter of engagement. And so you've got the liability to pay those costs, hence the reason why you need to get prospective approval. And so I think really if there is a shortfall, then the liability falls on the deputy. Now that's if there's a shortfall between the assessment. So obviously as part of that, then it's really the terms of the engagement about if they're effectively willing to have their costs on the basis of what is ultimately assessed and recovered. And that's very much how it works in other areas of litigation. So sometimes you'll have agreements with solicitors where they'll instruct us and we get paid what is ultimately awarded on an assessment, and there's nothing in principle to stop that arrangement between a deputy and their own firm, I think. So I think that's certainly my view on that. But Lucy, Sophie, have you got anything else that you want to add?
Not from me. We just suck it and see.
Sophie, you're on.
That is a motto for life, I think. And I suppose I just want to say, Helen, is that your real living room or is that a background?
I couldn't possibly confirm or deny. You know, I'll leave you to decide that one.
Okay, well, the three of you, thank you so much for joining me. I found that for my own purposes really, really helpful, and hopefully the rest of you did as well. But it just leaves me to thank you all for attending. What I do afterwards is I send out all the slides to everybody, and very often I get follow-up questions about random bits and bobs, cases, things like that. So feel free to email me. I'd be very grateful for any feedback that you have. And as I said, if there are any other topics that you would like me to speak on, then do feel free to get in touch. But on behalf of everybody here at King's Chambers, and certainly the Court of Protection and the probate team, I'd like to thank you all for attending and hope to see you all soon. Thank you.